So the DOJ, AG Bondi, and 25 states have now joined together in support against a statewide concealed carry ban that's currently in front of the Supreme Court. And now this challenge is heading to the Supreme Court conference next term. So let's break down what is happening. Now, real quick, if you're watching this channel, then obviously it's safe to say that you care about the Second Amendment and your rights. Now, here's the thing, even law-abiding gun owners are ending up in jail because they make a bunch of critical mistakes. And those are mistakes that you don't even realize that you're making or that you don't understand that they're illegal. So I put together a free resource called the Legal Survival Guide. It's aimed to help you guys avoid all of those traps that maybe you could fall in. It takes about 2 minutes to read. It's just a simple PDF, and it really could save you years behind bars. I made it to help you guys, again, completely free to download using the link down below. It's just something that I wanted to provide you guys for free so that you can have it in your phone or maybe print it out. And there's a little card also in there that you can put in your wallet to give you additional resources to help you in situations. Obviously, not meant to be legal advice. I'm not your attorney. This isn't an attorney-client relationship, but I wanted to provide you guys some free resources to prevent you falling in some bad situations. Again, if you're interested, click the links down below. It's completely free to do. All you have to do is enter your email to get that free PDF. As I mentioned in the intro, in this video, I have an important update for everyone in states like New York, California, Hawaii, and others who are currently facing attempts to ban concealed carry within those states. The state of Hawaii currently has a case in front of the Supreme Court, which is a case called Wolford versus Lopez, and it's a challenge against the state of Hawaii's ban on concealed carry within the state. And this is on an emergency review, essentially an emergency application to the Supreme Court, seeking for them to step in early and strike down that state ban. This challenge revolves around a preliminary injunction and the Ninth Circuit finding that states in their catch-all public property bans are permissible under the Second Amendment. Now, recently, to the surprise of many, the Attorney General and the DOJ have stepped up in support of this challenge and are challenging this state ban. This effort has now been joined by 25 pro-gun states, and they all joined together to argue the Supreme Court needs to review this issue. This challenge has gained a ton of momentum, and now it's heading for the Supreme Court conference, and that's going to happen at the beginning of the Supreme Court's next term in late to early September. Now, if you're not aware of what this case involves and what's going on with this challenge, essentially Hawaii had a new law that they put in place. It essentially restricts concealed carry, and that happened in direct response to Bruin. This law, like other laws, tried to add more restrictions to concealed carry and create a default rule where individuals could only conceal carry at certain public property or private property open to the public if the owner gave express permission. Hawaii, in response to Bruin, passed Act 52, a statute that overhauled the state's concealed carry laws, and that law essentially made concealed carry even worse than what existed prior in the state of Hawaii. Now, keep in mind, Hawaii already had very restrictive concealed carry laws. In fact, they had only issued a handful of permits over 18 years, and in one county, they had never issued a single permit. Now, because of this, plaintiffs, along with other 2A orgs, sued the state of Hawaii to strike down this law entirely. Now, on review, a district court issued a TRO, also known as a temporary restraining order, which was then later converted to a preliminary injunction. Now, in that decision, the district court blocked the private property rule as likely a violation of the Second Amendment, and they said that it was inconsistent with what the Supreme Court just said in Bruin. This case eventually made its way to the Ninth Circuit along with the California concealed carry ban, which challenged California's SB 2, the law that they put in place in the state of California. That is the May versus Bonta case, and it's a case I'm also a plaintiff on, along with Reno May and a lot of other plaintiffs in the state of California, challenging a similar ban that the state of California put in place. Now, on review, the Ninth Circuit upheld the catch-all property ban and reversed the injunction issued by the district court. The Ninth Circuit relied on older restrictions on hunting and private property to support that statewide concealed carry ban that was going on in Hawaii. After that, the plaintiffs asked for the Ninth Circuit to review the case en banc. However, that was denied, but you did have some judges on the Ninth Circuit, like Judge Van Dyke and others, who said that it was improper for their colleagues in the Ninth Circuit to deny review to this case, and once again, they were treating the Second Amendment like a second-class right. That has now led this case to seek emergency Supreme Court intervention. Now, this case has kind of a hard road in front of it, especially because the Supreme Court generally does not like to review preliminary injunctions. They do not like interlocutory review cases, and categorically, they have kicked all of these types of challenges. However, now with the United States and their support of this case, there is a better chance the Supreme Court will grant review to this case. Recently, the U.S. government and the Attorney General's office issued an amicus brief in support of this challenge, and in that amicus brief, they state that the near-complete ban is flatly inconsistent with Bruin and the long history underlying it. Bruin recognized that an ordinary, law-abiding citizen has a general right to publicly carry arms for self-defense. Now, one of the critical things in that brief is you have the US government saying that even though this is at a preliminary injunction stage, it's in an interlocutory posture, the Supreme Court should still step in because really there is nothing left to review at the lower court level. There is nothing else that needs to be developed, no other evidence that needs to be submitted. In fact, the state of Hawaii has conceded that in the Ninth Circuit. They point out that Hawaii in the Ninth Circuit argued that there was nothing else for the lower court to develop at trial and no further evidence that was actually needed for the review. This is critical for what Hawaii is now also arguing in opposition to the Supreme Court. And really what ended up happening is the state of Hawaii fell into a trap. This was pointed out by the recent brief that was issued by Mr. Wolford and his attorneys. In that brief, they state that Hawaii argues that this court should deny this petition because the record is undeveloped. That argument is irreconcilable with the concession in the lower court that no such further development was necessary. At oral argument in the Ninth Circuit, Judge Schroeder asked counsel for Hawaii, "Can I ask you a question on the preliminary injunction point? What else is there left to decide? What else is there to be litigated in this case?" And the counsel for Hawaii responded, "We think that there isn't anything. We think at the end of the day, these are not Second Amendment violations." Mr. Wolford and his attorneys point out that the counsel's concession on this issue is a judicial admission, which is binding and conclusive. That concession that there was nothing left to litigate was well taken. And they go on to point out that actually the Ninth Circuit relied heavily on that concession to then issue their judgment in favor of the state of Hawaii. So now they can't backtrack and say that, yes, there needs to be further development down below because they already conceded to the Ninth Circuit that that was not necessary. There was also some interesting back and forth in these briefs and also at the lower court about what type of history and tradition really should be relied on. Unfortunately, the Ninth Circuit leaned heavily on Hawaii's history and tradition, and the state of Hawaii also argues that its own state history supports this catch-all carry ban and should essentially trump the national history at large. And here in response to this, the plaintiffs argue that Hawaii seriously errs in contending that because it has limited the carry of weapons in public spaces since at least 1852, its default rule is constitutional. Effectively, Hawaii is claiming that its tradition trumps the founding. That assertion is self-evidently frivolous. So here the plaintiffs are pointing out that Hawaii has already conceded legally in the Ninth Circuit in front of that court, and for the purposes also of this petition to the Supreme Court, that there is nothing further to develop at the lower court level. There does not need to be a final merits decision. Also, it's clear by the arguments made in Hawaii's brief and also by what the Ninth Circuit found in this case that they did not rely on the proper type of history and tradition, which was mentioned in Bruin. The history and tradition of the state of Hawaii does not trump the nation at large. In fact, Bruin made this clear that outliers are not the norm. You should not rely just on outliers. Instead, it is what was the founding history? What was the founding tradition? And a state, local, one-off outlier should not trump everything else that happened at our founding. However, this case is now gaining a lot of momentum, and now it's set for conference on September 29th. And so this will now develop, and there will be a conference early next Supreme Court term. So they're going to consider this concealed carry ban. So this is a very interesting challenge. A lot of things have developed in this case. A lot of things have shifted, especially because the Trump DOJ stepped in on this issue. So now we're going to see how this plays out. If it's been set for conference early next term, and Supreme Court will decide if they want to take it. And it only takes 4 votes of the Supreme Court to grant cert. So as we get more information, as it develops more, I will let you guys know. If you want to support the channel, of course, subscribing to the channel helps. But you can also go over to my website, armscholar.com. We have a bunch of information over there also for free. You can get the free legal guide. All you have to do is sign up. You get, put in your email, and really the email is just for me. It only goes to me, and it's just another way that I can stay connected to you guys. But over on the website, we also have deals, merch, all that stuff that you guys can get as well. So thank you guys so much for all of your support. But as always, thank you guys for watching. Don't forget to like, comment, and subscribe. And don't forget, this nation was built by Armed Scholars, and this nation will be maintained by Armed Scholars.